with intent to distribute from September 19th, 2013, which is 15 SC 140132. We've heard testimony about that. And my client pled guilty to that, and we understand that that is listed as an overt act. So we're not going to specifically complain about the admission of that one. And the other one is possession of marijuana with intent to distribute, possession of firearm by a convicted felon from March 10th, 2016, which is 15 SC 140132, and I don't object to that. The other one I don't object to, I'm sorry, I read it wrong, Your Honor, it's 13 SC 121320. The ones I object to are 11 SC 98860 and 10 SC 87662.
Okay, well, they pled them specifically in the act, and that's Act 98, right?
Correct.
Okay, so I mean, if they're in proper form, wouldn't they go to an element? I mean, they go to an element of proof.
No, we could easily redact this indictment. We did it with count 25, I believe it was, on this indictment.
That was for another ground, though.
Well, it is, but I mean, it can be done. And the bottom line is all of this still needs to pass Rule 403. Just because the state puts it on a piece of paper doesn't mean 403 doesn't apply.
I understand. Okay. Well, if I understand your objection, are you saying that the court needs to apply the 403 balancing test? I mean,
yeah, as discussed in the Old Chief case and the other case that I cited, and many other cases, Your Honor. And also, I'll just point out the prejudicial value. The prejudicial value of these priors that are not listed as overt acts, specifically 10 SC 87662, is particularly great based on the charge being participation in criminal street gang.
all right. What's the state's position on that?
Your Honor, the state's position.
Can I see the convictions to begin with?
Yes.
You have them? You have them?
Yes.
Okay.
And just for clarity, for the purposes of the record, Judge, we have labeled State's Exhibit 31Q.
Hold on a second. You said 31Q, and which one's this one now?
This is the certified for 10SC 87662, Your Honor, which is a part of the allegation in not only count 98, but count 55 as well, as we discussed with Mr. Sharp prior to seeing the court.
Okay. What's the next one?
The next one is 32Q, which is the certified conviction for 11 SC 98860, which too is listed in both Acts 55 and Acts 98.
Okay.
We then have State's 33Q, which is a certified conviction for 13 SC 121320.
So 13 SC, what was that? I'm sorry.
121320.
121130?
No, Your Honor.
I'm sorry.
13 SC 121320.
Thank you.
You're welcome.
And what does that go to? Counts what?
And that too is listed in Acts 55 and Acts 98.
Okay.
And we also intend to introduce State's 30Q, which is the certified conviction for 19 SC 17371, which is the act itself that is alleged in Act 98. Part of the act. And I will present them at the court's pleasure whenever the court tells me to present them, to approach and present.
Okay, have you seen them, Mr. Sharp?
I have.
Can you
Yes.
approach, let me look, hand it to Mr. Kearns, please, so I can look at it.
And Your Honor, in reviewing them with Mr. Sharp, there are some sticky notes on there just to mark certain areas he wanted us to be mindful of
All right.
that had no bearing on the finding of.
Your Honor, may I add one thing to my argument?
Okay, this
Well,
trial's
actually,
been going
two.
on 10 years. Another 10 years coming.
We discussed some things and have.
Hold on one second, sir. Mr. Shaw, I'll let you know when I'm ready, okay?
Okay. Thank you.
Okay, all right. What are you doing the entire period of time I was here? Hey, come on, man, really? Time just one second, okay? All right, go ahead. As soon as he finishes.
John, I was going to add two other things. I just wanted to call your attention to the fact that both of these convictions that I'm arguing against are alleged to have occurred prior to the alleged RICO conspiracy. But also, most importantly, Your Honor, we shouldn't have to because we've basically done it in the opening, but we're willing to stipulate to my client's convicted felon status if that clears anything up. I mean, I don't think, again, from watching this case, I don't think that's an issue at all. And they have at least two prior felonies that seem to make that pretty clear. And we're not arguing that it's not clear, but we'll stipulate to it, in fact. But we just don't think it's appropriate just because the state throws things into the indictment to bring in bad character evidence against my client.
I don't think it's bad character. It's and they're not doing it for that particular reason.
Well, what is, I mean, I just don't understand what the reason is, because the only legitimate reason is to prove he's a convicted felon, and he clearly is. So,
Well, I'll let the state respond to that. Is that the two bases?
yeah, we're willing to stipulate.
Okay, all right. Yes, Ms. Love.
Thank you, Judge. Your Honor, what it seems that Mr. Sharp is doing is asking for essentially a striking of the indictment, something that should have been dealt with pre-trial, because where we are now in Act 55 and Act 98, these are portions of the act that the state alleges, so they constitute proof of what we've alleged in the indictment. As to the argument regarding 403 and a 403 analysis, these allegations are not allegations that, or the certified convictions rather, are not convictions for the types of crimes that are substantially more prejudicial than probative as they relate to Mr. Sharp's client. The fact that he now asserts that these crimes happened prior to the beginning of the alleged conspiracy is of no consequence, especially where it's these acts that have occurred are in fact kind of integral to other evidence that will be presented at trial. Mr. Stillwell, in that 10 SC 87662, committed those acts as part of the criminal street gang that we do reference in this indictment. We talk about 30D. We talk about not just YSL. Mr. Stillwell, in one of the songs or lyrics that may be talked about, there's a reference to the Blue Jean Bandits. There's a reference to 30D. And this is just ancillary, but this gang charge that is alleged in 10 SC 87662 is in fact one of those kind of incidents where she is alleged to have and actually was convicted of gang activity for that type of act on his part, along with others. But that aside, Your Honor, the bare fact is that the state has alleged in Act 55 and Act 98 that Mr. Stillwell had been convicted of these offenses, and the state has the right to prove up its indictment in the way that the state sees fit. This is not one of those circumstances where the convictions in any way prejudice Mr. Stillwell, and certainly they don't substantially prejudice him in a way that makes the admission of these convictions more prejudicial, substantially more prejudicial than probative. He's essentially trying to dictate the way the state proves up its case, and the defendant doesn't have the right to do that. The state has the right to prove up its case in the most effective and impactful way that we are legally allowed to do. And given that we have made these allegations that this indictment has been read to the jury and that we have bona fide certified copies of these convictions, the state should be allowed to introduce that evidence to the jury and should not be kept from doing so for reasons that are not, there's no reason to keep the state from doing so. The defendant just does not get to dictate how the state proves up its case. So we are just asking that the court deny these motions to keep out evidence of acts that have been alleged in our indictment.
And Your Honor, they keep saying I don't get to dictate how they try their case, and I acknowledge generally that's true, but that's the whole holding of Old Chief, is just because they allege it in the indictment doesn't mean they get to just let everything in, no matter how prejudicial it is, no matter how limited the probative value is. That's the whole point of Old Chief.
Old Chief is a little different. Old Chief, this is Old Chief versus U.S. 519 U.S. 172. A little different aspect. I see what you're saying about Old Chief in terms of you're willing to stipulate that particular issue in terms of the convicted felon issue, which is Old Chief was a singular issue, and that's part of why the Supreme Court dealt with it in the manner that they did. The state is alleging, however, that given the other elements of proof that they're alleging, in particular Acts 55 and 98, 55 being
They're just,
the defendant from the incident involving 7/15 of 2015, defendant Shannon Silva, associate of YSL, did commit the felony offense of possession of a firearm by convicted felon in violation of Georgia law pursuant to OCGA 1611-131 by possessing a firearm, to wit, a handgun, after being convicted of a felony in indictment 10 SC 87662 in the Superior Court of Fulton County for the offense of participation in criminal street gang activity and burglary on the 26th day of May 2010 in indictment 11 SC 98860 in the Superior Court of Fulton County for the offense of burglary on the second day of June 2011 in indictment 13 SC 121320 in the Superior Court of Fulton County, Georgia for the offense of possession of marijuana with the intent to distribute on the 19th day of September 2013, an overt act in furtherance of conspiracy. So, and then in addition, in Act 98, they allege similarly participation in criminal street gang activity and these acts in furtherance of overt acts and furtherance of conspiracy. I know it may, in looking at it from a 403 perspective, Mr. Sharp, and of course, in looking at Old Chief and looking at what the measure of prejudice is, evidence is unfairly prejudicial when it would influence a jury to decide the case on an improper basis, and courts have noted that there's a difference between evidence that is simply prejudicial and in that it hurts a party's case admissible, and evidence that's unfairly prejudicial, which is inadmissible. So the 11th Circuit, in looking at this particular issue, in the United States versus Patrick, that's 513 F APPX 882, 11th Circuit, 2013. While invoking the exclusionary elements of 403, in addition to cautioning that the rule should be used sparingly, the 11th Circuit Court of Appeals looks at the evidence in light most favorable to its admission, maximizing its probative value and minimizing its undue prejudicial impact. Consistent with this authority, courts have noted that the key term in 403 is not prejudicial, but unduly. So in this particular circumstance, I don't believe that these particular convictions, now there are some things in there that will need to be discussed and paired out before actually being handed to a jury, but I don't believe that this is going to lead to confusion of the issues, mislead the jury, be a waste of time, unduly delay, or needlessly present cumulative evidence. So applying a 403 analysis, I believe these convictions, if in proper form, would be admissible to prove the state's case, or attempt to prove, I should say, because that's a jury's issue, whether or not they proven to a satisfactory extent Acts 55 and 98.
well, Your Honor, just briefly, if I can respond, the proof, it is cumulative, and
We're gonna disagree about that, okay?
if it's just to prove his convicted felon
No,
status.
they're going to prove whether or not, as listed in the indictment, whether or not they're acts in furtherance of the conspiracy. So a jury's free to believe, it's just because they introduce them doesn't believe that they have to view them as proof positive.
They haven't, but there's different evidentiary means for them to get.
But they get to choose that. You
But
and I
they haven't
don't.
filed the pretrial motions to, like 404B. They would have to file a 404.
They're not required to do 404B. It's not mimic evidence. Okay.
On a burglary from 2011.
It's going to be what they allege in the indictment. So they have to be able to show that.
So
Prove
it's
it.
going strictly to his status as a convicted felon, because that's the only thing that they've
Well, it's part of the elements in terms of, because one, you got to show whether or not he's a convicted felon or not. So yes, that goes to one aspect of it, but it's not, as an old chief, it's not the sole aspect of it. They've got multiple reasons as to why they're seeking that particular evidence. So,
And Your Honor, all I'm saying
if it was just that, then I would more agree with your particular assessment that the 403 balancing test would tip. In this particular circumstance, it goes to more than that.
But they haven't provided the pretrial notice to use it via other evidentiary means or vehicles. So in other words, they can say, oh, well, it proves Mr. Shannon Stillwell has a propensity to do this, or whatever their argument is.
They wouldn't be able to argue that. That would be error for them to argue that.
Well, let's just say that it proves his gang membership. Just that's an example. They would have to file.
As in the indictment.
And they would have to file a 418 notice.
We talked about this before.
And those aren't listed on it. That's what I'm saying.
This isn't other acts evidence.
Well, then what is it? It's just proof of conviction.
It's overt acts in furtherance of the conspiracy.
They're not listed as overt acts on the indictment.
That's what that's how the indictment's read. I read the indictment.
I'm not disputing that they can get into overt act 98. All I'm saying
55.
I'm not disputing that at all. All I'm saying is they can't bring in certified convictions after certified conviction after certified conviction as an element of that act.
It's only one element of whether or not he's a convicted felon.
They only need one
but
conviction.
But that just goes to show. But it's more than that. They're going to show one. I mean, and look. You've asked. You're having discourse with the court.
Yeah.
So I'm just saying that it also goes to show whether or not they committed, or your client, whether or not they can prove your client committed any of these acts in furtherance of the conspiracy. Now, they may be able to show he's a convicted felon, but if the jury doesn't believe the other stuff, then that's only one thing. Now, whether or not he can be convicted of something else is another thing, but it's part of their proof in this case. I think it goes to multiple reasons, but State, you have anything else you want to add?
Yes, John, a couple of things. One, the state does not have to allege every overt act. And two, these are also intrinsic acts, and they don't have to be provided as with pre-trial notice of intrinsic acts. These are all part and parcel of the alleged conspiracy that we have charged the defendants with in count one. So this argument about 404B fails. The argument about pretrial notice fails, and this is.
I still have to apply 403 though.
Oh, I do. I didn't argue about 403.
All right. Okay.
I didn't.
And
Okay.
I just don't see how these are at all intrinsic to when they occurred before any RICO conspiracy is alleged to have begun. And Your Honor, I appreciate you hearing me out.
No problem.
And there's one other issue that we could take up, but while the jury's out, we might as well now. There's a photo that the state has indicated that they wish to admit, likely through a witness this afternoon. It's 26Q. It's been previously marked as 26Q. Your Honor, I would just describe it. It's a still off of a body cam.
Can you
Yes.
see it? Let me see it.
And, Your Honor, to add context, in this incident that we're litigating this afternoon, my client is alleged to have been involved in a car wreck.
Okay, what is 26Q?
That is the driver. Apparently, after the wreck, the police dragged the body. He's alive, obviously, but they dragged the body of the man from his car and placed him on the grass, and they didn't know if he had any spinal injuries, which he didn't have, and they told him to lay there on the grass and remain still. And so I think that's a depiction of the man laying on the grass, remaining still. I don't know why we need a picture of the man who was driving the other car, laying in the grass, remaining still, following orders. I think it gives
On the phone or something like that, or
I think he's talking to, yeah, in the body cam, I believe he was talking to a friend. But I think it gives the impression that this man was seriously injured and potentially can't move, which wasn't the case. And I just don't see the status, the state of this man that was unfortunately in this car accident. That has absolutely nothing to do with what we're litigating today. I don't see how a hit and run, first of all, I don't think it's even relevant to a hit and run, but to the extent that it is, certainly a hit and run would not be, I don't think even the state would argue that that would be in furtherance of any RICO conspiracy. So I believe that it would be, I didn't say anything about.
So are you saying it's relevancy? Is that what you're asking me to?
403, yes, it's confusion.
No, that's different. Right.
It doesn't have any relevance.
Relevant is a threshold issue.
Okay, it doesn't have any relevance.
Okay, all right. State anything as to 26 Q or Quebec?
Yes, Your Honor. For 26 Quebec, the state feels that it is relevant. The previously admitted 23 Quebec and 24 Quebec would show this white Ford Fusion. Mr. Montgomery was the operator of that Ford Fusion. The state, that picture is just him laying on the ground, Your Honor, as you can see up there on his back. The state's not trying to get into whether he had some kind of back injury or spinal injury. It's specifically to corroborate what already Officer Cogdell has testified to and what Officer Raymond, who the state tends to introduce that through, that there was two cars and there's a diagram of this intersection that the state tends to introduce, which is 27 Quebec. And so the state just wanted to have the jury to be able to visualize the driver of the other vehicle.
All right. Mr. Short, unless you have anything else, I'll preliminarily say that I'm going to admit 26Q or Quebec, okay?
Thank you, Your Honor.
All right. As for states, 30 Quebec, 33 Quebec, 31 Quebec, and 32 Quebec, given the pronouncements of the court, I'm going to admit those. However, you have one here, should say state, let's see, that would be 31 Quebec, where you would need to redact or otherwise not include the revocation matter. Okay, so that needs to be stripped out anyways, but, and we can talk about that later anyways, because I think that there's a lot of allied papers that you probably have that probably don't have any, that wouldn't go out to the jury anyways. So, I'll admit them, but I'll say that you will have to, at some point in time later, unless you're going to show them to the jury at this point in time.
On one of those convictions, it appears that there's one of the old Fulton County handwritten sentencing sheets, and then also the computer-generated computer-generated sentencing sheet as well. So it's almost like it's double. It's the same conviction twice. I believe that's on the Gain case.
Your Honor, that is another matter that we have no problem hashing out with Mr. Sharp prior to that document itself going out with the jury. I think it's along the same lines of probation, revocation, paperwork. It is in fact an exact duplication. Otherwise, we would address it at a later time with the court.
Are you going to read it in any way to?
We're going to read the computerized copy because that's the one we read.
All right. Mr. Sharp, other than your objections, is that all right with you, sir?
Yes.
All right, just make sure that you all, before, I mean, that is the state and Mr. Sharp, get together and figure out exactly what's going to be read. But I'll admit those over the objection and make them continuing objections,
And
okay?
Your Honor, if it's okay with you in front of the jury, I'm just going to say that my objections are the ones that I've previously stated
That's fine.
and assume that we will remedy the extraneous papers at a later date.
Yes,
Thank you.
okay.
Your Honor, just permission to come approach and.
Oh, yeah, you can, yeah, Mr. Kearns, go ahead and give those back, please. Okay,
Thanks.
all right. All right, before we go ahead and recall our witness, how much longer do you think we'll need, Mr. Sharp?
With this witness, I would say 10 to 15 minutes.
Okay, we'll probably call it a day after this. Okay, if that's all right with you all. Okay, all right, okay. Anything else? Can we summon our jurors? All right. Oh, bathroom break. That's right. Okay, folks, I'm sorry. I apologize. Let's just take, we'll be in recess 5 minutes. You all need, and then do what you need to do, and we'll come back and we'll go ahead and finish up. All right, we're in recess. Don't go anywhere. Don't go anywhere. Don't go anywhere.
All right. Why don't they be in recess another 10 years? That's what's up. So, hi, how's everybody doing? All 2 of you that are here, thank you for being here. Okay, hi, how you doing? How you doing? There's a lot of drama going on the tubes, ain't there? Glad I'm not involved. Hell no. I don't see how people can be that angry all the time. I mean, I don't get... Grandma, where the hell have you been? Okay, so let me continue. Now, I can't be angry. There's times that, I get mad, but, I'm over it within seconds. Why hold on to that ickiness inside? Right? Right. Tallahassee. Is that where you're at? I'm cooking. Did you are you guys talking behind my back, you two? Are you guys talking behind my back? Just kidding. I'm messing with you. Your half-hour south? Oh, are you? Okay. So yes, I'm cooking, and I'm so happy there's a trial on right now because I've been so bored of the internet. So bored. What? Are you okay? Right. Breathe in, breathe out. Breathe in, breathe out. So I am cooking for me and my dad because I cook for him every night. I am making pork chop. He's going to make potatoes though because I'm making this recipe that has to do with hash browns, cream chicken soup, sour cream, cheddar cheese, butter, cornflakes. It's my new thing, guys. It's a new thing I like to eat. My daughter introduced it to me and I love it. Healthcare billing, ew, yucky. Wow. But yeah, that's what I'm having. All right, got that done, you guys. I got the onions done. The onions are done. I forgot to say onions are in it too. I sauteed them, okay? Just until they were translucent. What's that word again? Translucent? Yeah, you guys know what I'm saying. You know I struggle with words. Okay, so what I should do is I should take a picture when those are done and put it on my community wall. Yeah. So it's 30 degrees where I'm at and holding. I love onions. I can have onions in everything. Everything. Sure can. Yes, girl, yes. I was looking for some stuff for us to watch. You know, when I know we're gonna get to Carter's and Hoppa, okay? We will, I promise. Okay? But I was looking into some other things too. Uh like okay, what's the word here? I gotta think of the wording here. A discussion. Okay? Oh no, I don't eat them raw either. Nala does, because she's naughty like that. Hold on, my dad's here. What the hell do you want?
Hey,
What?
you can check your gas tank?
Yeah, you filled it up for me.
Being Nelson.
I know, thank you. I said thank you, Dad.
Yeah, you do it because cold weather's coming, but you don't think.
Okay, asshole. Here, take this.
Think what?
Right here, I got this.
I got one of them downstairs too.
Well,
You don't
okay.
need that. You need
No, okay, Dad, thank you.
24. Yeah.
Okay, I'll bring you the pork chop in an hour.
Huh?
I'll bring you the pork chop in an hour.
How many? One or two or three?
One, Dad.
I want two.
Okay, see you later. All right. Just so people know, this is normal behavior with us. You usually hear him call me a bitch in the conversation. Okay? That's his favorite word to call me because we are dysfunctional over here and I can admit it. Okay? But there's love all around. Love, you get it? Love. See, people won't understand. My dad was, how old was my dad? My mom was 16 when she had me. So that means he was 18. No. Yeah, 18. So I grew up with my parents. And there's that. And you guys, I do not like the short-haired prosecutor in this case. Okay? And on the defense side, I like Steele. I like that attorney. He's entertaining. Now, I like the judge, but I'm kind of having a problem with the judge because when the defense, does an objection, the judge never lets them get their way. It's never overruled, you guys. But, never know. I know there's nothing wrong with cussing. Some people are weird with it, but I don't know. It's just, it depends how you grew up. You know what I mean? I'm at a minimum here, though. On YouTube, I try. I try. I can't get my dad on camera, though. When I tell him I'm live, he goes around in the other room. I'm like, the camera's off. Nobody can see you, dummy. Let me tell you, this trial is going to take another 10 years, guys. So maybe in 20 years, this is going to be taken care of. What do you think? No. I just read that again. Yeah, it's always a joke. It's never serious. I would never disrespect my parents like that, ever. Anybody for that matter. Unless they're really, 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 really mean to me. Right. So we got some trials coming up in 2024. Supposed to be Leilani, Simon, Evelyn, or not Evelyn. Oh yes, baby Evelyn, sweet little girl baby. Her mama. What the hell's her name again? Boswell. I know the baby's name. What the hell's her name? I've talked to the girl. I know, because it don't bother me. You know what? The word CUNT, see you next Tuesday, don't even bother me. The craziness I have grown up with, and I know how to be an adult, like in the public eye and stuff, right? I know how to be responsible. And so there's that. Grandma, do you remember me streaming this trial a while back? Well, one of the guys there got stabbed in jail. So yeah, they've been off for about a month. Yeah, I'm careful. You know what? I don't disrespect people out in public. No, I'm not like that. What I like to do is say hi to everybody. That gets them every time. Hi, how you doing? My grandkids will say to their mom, Grandma talks to everybody. I'm like, yes, I do. Okay. Where's Ducking go? I wish they would hurry up. I gotta continue cooking. Oh, that's right. You're working. I'm sorry. That's right. You already said you're doing paperwork. No, never. We scared somebody and we didn't even know it. Right, Grandma? We didn't. And I say we, and I can say we here because we're a we here. Okay? We didn't do nothing to that person. Nada. Nothing. See, I'm still shocked about the whole situation. Obviously, because I'm talking about it. Right? We welcome everybody here with open arms. There's no echo chamber here. You can say whatever you want to an extent. To an extent. That's why she was in another chat. She said people are fighting. I believe it. That shit rubs off on you. You know what I mean? It does. Yes, it was unexpected. And here we were all worried about her, thinking, oh my God, because she's on oxygen and shit. What happened? But that's okay. We still care. And we hope she's happy in her life and stays healthy and alive. We were the night before. Do you remember? You, Jimmy, Miss Barbara, and Far Q. That night, you guys were laughing up a storm. It was funny reading everything. Yeah. Yep. Too bad. I've never been in that type of situation that because a creator don't like another creator, so then if the other creator decided was theirs first, why do they feel they have to appease by that when we all got free will and we are not sheep? We can have our own opinions respectfully, agree to disagree, right? Am I right, Grandma? Or am I off? I love getting your opinion. You know that. I know. I could never tell anybody what to watch. I haven't seen a lot of that, okay, on here. Don't you come in my chat. I seen you in that chat. I'm blocking you. I'm like, wow. Are you fucking kidding me? You people are in your 40s and 50s doing this. And 60s, I must say. Come on now. Right? Right. Okay, so now what I'm looking into, to have our little discussion group or whatever, you let me know what you think, Grandma, like always. Serial killers. How about that? And it was rough yesterday, really listening to, yes. I know. Because you know what? You're like me, and you take that people's, that feeling on towards yourself in your heart, and it's heavy. You know what I mean? What can you do? You know what I mean? Yeah, I hope she gets help. I feel allegedly she's on a downward spiral. She's a beautiful girl. There you go. You know what? They're going to come back and you know what? Because it's already 5:09 there, or 5:03. They're going to tell the jury, we're going to go home for now. And here we waste our time. I feel like crap when I see stuff. I know. That's like, with BHB, she's entertaining, but when she's angry like that, I mean, she was going bipolar yesterday. It was crazy. I think she needs some medication, allegedly. That jury has been out of the courtroom since, I want to say 1 o'clock. I could be wrong. I didn't know. She attacked a family. I did a video. I did a criticism video for educational purposes yesterday. I was in shock. Well, you know what? I don't think she'll ever shock. And I will always be shocked. Always. Just embarrassing. Sammy Sodas, that 18-year-old that was pregnant in Texas, and her boyfriend, Maurice. But she went after the family, the grandma and the aunt. Yeah. Oh, look at, are they coming back yet? No. Oh, yes, she did. And I couldn't even watch the whole thing. Nope. I only lasted, what? How many minutes? 20 minutes? Because the family is getting harassed on the internet with comments and people going after their real lives, even though these guys are victims. The families are victims. They're going after their lifestyle, their just a bunch of different things. So they were on a news station asking them to please be kind, let law enforcement do their job, and they had to get off of social media because of everything. Yep. I check in every now and then. I mean,
Notice, we're going to probably not get to your witness today.
oh, of course.
I'll ask the state when they believe that they will get your witness so you can schedule accordingly. But we're going to finish after this cross-examination for the day. So, counsels for the state, when do you anticipate calling Ms. Gladden's client? What's your name, your client?
Shantavia Stevens.
Mr. Stevens. Okay.
Your Honor, as we have spoken with Ms. Gladden and Mr. Stevens over the weekend and informed them, we did intend that to get to him today if we had reached him. So we will be getting to him tomorrow.
Okay, all right. So, Madam, tomorrow, if you could be present for you and your client for 9:30?
Thank you so much.
Okay, all right. Do you have any other business before me, Madam?
I do not, may I be excused?
Yes, you and your client may be excused until tomorrow morning at 09:30, okay?
Thank you,
All
Judge.
right, we'll see you then, okay? Okay, all right. Sergeant Ingram, can we go ahead and summon our jurors first, please?
All rise for the jury. All rise for the jury.
Yeah, all right. I have no idea because there's a bunch of people angry ladies. You will not. And what is kind of funny about
It's
it,
like, I haven't had two of this stuff. It's gonna be great.
her text
I was like, immaculate.
where Layla's mom, and then she does this. No Amazon does that, right? Right. Then I know I'm like, nobody asks for help. It's not
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. Okay, Mr. Short, cross.
Officer Cogdale?
Yes, sir.
Good afternoon. My name is Max Shard. I represent Shannon Stillwell. I think you referred to him as Shannon Jackson.
Correct.
Okay. You said that you were assigned to Zone 3
Yes.
and a specific beat within Zone 3 that includes the Cleveland Avenue corridor, correct?
Correct.
Okay. And what year did you begin in Zone 3?
In April of 2019.
Began April of 2019?
Yes.
Okay. And are you still in Zone 3?
I am.
Okay. And the same beat?
Yes.
Okay. Prior to this incident, you did not know, or you had never personally interacted with my client before, correct?
Correct.
Okay. Is it fair to say when you saw the red car driving down Metropolitan, you did not recognize my client in the car and say, oh, that's Shannon Stillwell?
No.
Okay. No, meaning you did not recognize him.
I did not know who he was.
Okay, excellent. That day, you indicated that you were in a police car in a parking lot of a storage company or
Correct.
storage facility, and you were by yourself in that car.
I was.
Okay, and I believe you used the word set up or posted up.
Posted.
Posted. How long were you posted there prior to getting behind Mr. Stillwell's car?
I'm not for sure. Probably 20 minutes, probably.
In that same parking lot, looking over or looking at Metropolitan.
Correct.
And what were you looking for?
Just monitoring traffic flow. Any traffic violations that was committed.
Any traffic violations?
Yep.
Okay. Now, you indicated on direct that you saw my client in the front driver's seat, you said dancing.
Correct.
Okay,
Like bouncing around.
bouncing around as some of us tend to do when listening to music in the car?
Correct.
Okay. You did not observe any moving violations committed by Mr. Stillwell at that time, correct?
No, just the seatbelt violation.
Just a seatbelt violation, meaning despite enjoying the music in the car, he wasn't weaving in between lanes or driving recklessly at that time?
No.
Okay, it was solely a seatbelt violation.
Correct.
Was that the only seatbelt violation you observed that day?
I'm not for sure because I got to work a little bit late that day. Who knows?
Do you always pull people over for seatbelt violations?
Not always seatbelt violations, no.
Okay. Nonetheless, you decided to get behind Mr. Stillwell's car, correct?
Correct.
And you in fact blue lighted his car, correct?
Correct.
All right. And eventually you pursued Mr. Stillwell's car, correct?
Correct.
Whose decision is it to whether or not to pursue an automobile that is not stopping?
It depends. It's the supervisors monitoring. They can monitoring the radio traffic. They cancel us if it's not like a forcible felony vehicle, or I can cancel myself.
Okay, so you said they'll cancel you if it's not a forcible felony, correct?
Correct.
Okay, and you would agree that seatbelt violation is not a forcible felony?
Correct.
APD standing operating procedure is not to conduct a pursuit on a seatbelt violation, isn't that correct?
That's correct. And I was getting ready to cancel myself, but by that time, he had already got into the accident.
Now, we talked about you were using some codes on your body cam that was shown to the jury.
Mm-hmm.
And you said, I believe, a code attempted 44?
Correct.
Okay. And that involved a young lady that we don't know who she is that was on the scene, correct?
Correct.
All right. And just to be clear, all the interaction between Mr. Stillwell and this person was captured on body cam.
Just that, yep.
So when you're saying you observed my client push a woman, that was what we saw on body cam. There wasn't something else.
That was it.
Okay. That interaction, did Mr. Stillwell ever pull anyone out of their car?
No.
Did Mr. Stillwell ever take control of anyone's keys?
No.
And all this was observed by you as Mr. Stillwell was running from you, correct?
Correct.
That person whom we don't know their identity did not stick around at the scene to file any complaint, correct? In the days that followed, did that person ever come into a police station and say, hey, I was on Cleveland Avenue on this date and this is what happened to me? Did they make any sort of report at all?
Not to my knowledge, no.
Okay. The $5,000 that, or I guess it was $5,500 ultimately that was recovered from my client's pockets. Was that money returned to him?
It was placed in the evidence.
It was
Placed in the property, placed on hold.
It was placed on hold for seizure, correct?
Correct.
Okay, so that it was not returned to him.
As far as I know, no.
And it was seized by the government, by you, as an agent of the government.
Yes.
Now, Mr. Stillwell had that $5,500 in his pocket, correct?
Correct.
Do you have any information as an investigator in this case that that $5,500 belonged to anyone other than Mr. Stillwell?
As far as my knowledge, no.
As far as your knowledge, that was his money, correct?
Correct.
And no one else's, correct?
Correct.
Let's talk about the red car, the red Nissan. I think we said it was essentially it was an Altima, correct?
Ultima, yep.
Right. That car, certainly as an or as an officer in this case, you ran that car, correct?
Correct.
To figure out who the owner of the car was, correct?
Correct.
To figure out if that car was stolen, correct?
Correct.
Okay. That car was not stolen, was it?
It was a rental car.
It was a rental car. So I'm going to ask the question again. That car was not stolen, was it?
No.
Okay. And it was a rental car.
Correct.
And it was rented by Mr. Stillwell's girlfriend, correct?
That I'm not for sure. The rental agreement wasn't in the car.
Okay. You have no evidence to suggest that someone rented the car and then it was subsequently taken from them, correct?
Correct.
Okay. Everything was legal about the car.
Yes.
And it was a rental from Hertz, correct?
Correct.
All right. Now, let's talk about the firearm that was recovered out of the center console. Do you remember on direct where the you testified that it was not reported stolen, and then the state asked you, well, if it was stolen but never reported stolen, it wouldn't show up as stolen, correct?
Correct.
Okay. And that's true, correct? All right, so let me ask you, instead of speculating, in 2019, was there any evidence at all that that firearm was stolen?
No.
Okay. In 2024, as we sit here today, do you have any evidence at all that that firearm was stolen?
As of today?
Yes. I mean, since this happened, has any other evidence come in that changes your assessment?
Not my assessment. And once it gets turned in, it gets turned into ATF.
Okay, so in 2024 today, you do not have any evidence that that firearm was stolen?
No.
Okay. Do you have any evidence that that firearm was linked to any other cases?
No, not to my knowledge.
Okay. And I believe on direct, just to clear something else up, initially you testified that that firearm was a 9mm, it was a 45.
It was actually 45, yes.
It was a 45. Okay. All right. So, and you've had an opportunity to view your body cam?
I did.
All right. So and I understand that this was 4 years ago, more than 4 years ago, but in viewing the body cam, did it help you remember or recall some of the specifics about this case?
Yes.
Okay. So in your dealings with Mr. Stillwell and in searching the car, I want to ask you, did you find any gang other than Mr. Stillwell involved in this case?
As far as like outstanders or officers?
Suspects
Suspect, no.
in committing this crime, correct?
Correct.
Okay. There was no one else that came and claimed possession or possessory interest in this firearm, did that?
No.
And you determined it was Mr. Stillwell's
Correct.
and only Mr. Stillwell's?
Correct.
Okay. The money that was found on Mr. Stillwell, you determined, although you seized it, you determined that it was Mr. Stillwell's money, correct?
Correct.
And only Mr. Stillwell's money, correct?
Correct.
Okay. And Mr. Stillwell, let's talk about his clothing that day. He was wearing black sneakers, correct?
I believe so.
Black jeans
Yep.
and a blue and teal flannel shirt, give or take.
Yeah, almost greenish.
Greenish. Okay, I'll go with you. Greenish flannel shirt. Okay. All right. And when it was time to charge this case, sir, you charged And you took out the warrants in this case, correct?
Correct.
Okay, and you took out warrants for what you deemed appropriate to take out warrants for.
Correct.
And you charged Mr. Stillwell with fleeing and attempting to elude misdemeanor,
Correct.
okay, for driving off.
Correct.
When you were trying to stop him for the seatbelt violation, correct?
Correct.
You charged him with hit and run,
Correct.
obstruction for running from you,
Correct.
okay? No license,
Correct.
seatbelt violation,
Mm-hmm.
and possession of firearm by a convicted felon,
Correct.
based on his status as a convicted felon.
Correct.
You did not charge him with any gang act violations, did you?
No.
I beg the court's indulgence.
Yes, sir.
Thank you, officer. That's all I have, Judge.
Any redirect, counsels? All
Yeah, very brief.
right, go ahead.
Officer Cottington, Mr. Sharp asked you, I wonder if you remember if there were any other seatbelt violations. You were asking you if you observed any other seatbelt violations that day.
Yeah, I did.
Yes, you remember, Mr.
Him asking the question, yes.
On that day, was that the only seatbelt violation that fled from you?
Correct.
And do you have any idea why Mr. Stillwell Jackson was fleeing from you for a seatbelt violation?
No.
And the only thing you were intending to stop him for was a seatbelt violation.
Correct. If he would have stopped, I would have told him to put his seatbelt on, let him about his business.
But he fled.
Correct.
No further questions.
Anything further, Mr. Sharp?
No, Your Honor.
Anybody else? Okay. May we permanently or temporarily, excuse Officer Cogdell?
Temporarily.
Okay, Officer Cogdell, I'm going to temporarily excuse you as a witness. Please don't discuss your testimony with anybody except the attorneys in this case. The state will be back in touch with you when and if you need to come back, okay?
Okay.
All right, thank you for your patience, sir.
I made a video yesterday about it.
Okay, ladies and gentlemen, the hour is almost 5:30. It's probably a natural stopping point at this point in time, so we're going to recess for the evening at this point. Tomorrow, I'm going to ask that you all be here tomorrow morning for 9:30 for an anticipated 10 o'clock start time. Okay, that's what our, and then we'll work and see where we see where tomorrow leads us. Okay. All right. So before we recess for the evening, let me give you your official ad nauseum admonitions. Remember, as we're going home tonight, all the things that we talked about during the time period we've been here still apply. Very important, and I know that it's really hard for those that love you and know about you sitting here and what you're doing to not ask you questions about it. And remember, you can blame me and say that Judge Glanville said, really, I cannot talk with you about this. So I'd ask that you kind of remain steadfast in that particular vein. The other thing I would also just remind you about again is that, and the reason I asked you about coming off of social media is that the temptation for third parties to reach out to you is pretty great. So if you're off social media, then that lessens anybody trying to kind of reach out to you for any type of improper purpose that I told you about earlier. And of course, if anybody should reach out to you, you would need to let me and or Sergeant Ingram know immediately. So please consider that. And also, I would also just remind you as well, I asked you all to not use social media at this point in time. That doesn't mean that third parties won't try and talk with you about what's going on outside. And remember, what goes on outside is not of any consequence, because remember what I told you, you can only consider what's lawfully presented in the four walls of this courtroom, and you cannot consider any other source or sources to get your information from and or share that with each other. Remember I told you that most people get in trouble because they'll come in here and they'll say, hey, I was doing such and such and such, such, and then you get busted. So again, keep doing what you're doing. Be mindful of, of other influences. And if you should have anybody try and reach out to you, go ahead and let us know immediately. But to that extent, ladies and gentlemen, we really appreciate you continuing to honor these admonitions, because remember, as I told you, from day one, they ensure a fair trial, just trial, lawful trial as to all sides. Okay? So, okay. As you can see, we made some capital improvements in your space. Hope you like those. Our continuing efforts to make you as comfortable as possible. Is there anything that any of you need to ask me at this point in time, ministerial in nature? Okay, all right. Just to put a couple things on your radar, the week of the King Week, the King holiday is on the 15th, and that week I think it follows through the 19th. We will be taking an administrative pause. So if you have any things that you need to schedule, that's a week that's good for you. Okay. So just to put that on your radar as of right now. There's some other unrelated business that we'll take up. And just to put that, as I told you earlier when we started, I'll try and give you as much notice so you can go ahead and schedule other things that you need to do, because your life still exists and continues to go on, even with this very important responsibility that we've asked you to take on. All right, ladies and gentlemen, unless you have anything else from me, remember also leave your notepads in the basket. Are we okay with notepads?
Yes.
All right, if you get down to where you need some additional ones or new writing utensils, please let Miss Amana know, and we'll go ahead and get those to you immediately, all right? Okay, unless you have anything else of me, ladies and gentlemen, thank you for your patience and continued patience that you're continuing to give this matter. And unless you have anything else, we'll see you tomorrow morning at 9:30, okay? All right, all rise.
Thank you, Grandma. Thank you for being here, like always.
I'm walking toward the door.
I said, thank you for being here, like always. Woman?
All right, ladies and gentlemen, please be seated. Okay, folks, just to get back in the habit, if you could turn in your listening device so we can charge them. Does anybody else have anything else I need to take up with the court before we recess for the evening? All right, hearing none, we'll see everybody here for 9:30 tomorrow morning, and then we'll start when everybody's accounted for. So we'll be in recess until that time.
Thank you.
All right.
Isn't that a waste of time, Grandma? Can you hear me now? I'm multitasking as we speak. See, because this morning I covered this right. Okay, when it started, all right. Then they went on a break. I mean, they've been out of the courtroom more than they've been in. Yes, yeah, adorable, ain't it? It's my naughty little girl. So with that said, I'm going to go finish cooking. I want to thank everybody for being here. Grandma, like always, like Duncan, and I like to call her Dunkin', like Dunkin' Donuts. I want to come live later, but okay, instead of me talking all the time, because I hate hearing my own voice, I want to find something educational for us. I only like sit with him because he lives next door. I only sit with him like on holidays. We just do our own thing. You know what I mean? But we're here for each other. And he's got Nala right now. And I'll go get her at 9. Hey, girl. Hey, you're still here. I know. Remember I had all that stuff saved on my computer? I've been having problems with my laptop. It's going to hell, okay? And I lost a bunch of shit on my computer. Oh, well, huh? And then, well, I'm feeling pretty good today. I'm not depressed. Happy. Everything's going okay. It's been a rough couple months, but, everybody has problems. I just get really, really quiet. Believe it or not, Grandma, I do. I get quiet. But not today, people. All right. I love you guys. Thank you for being here with me. Have you? I get quiet. You know that. I still haven't looked at all my messages. See, if you have an iPhone, you can tell if I looked at your message or not. My daughter taught me that, okay? But I still have 74. Yeah. Yeah. All right. Okay, I'll see you guys later. Peace and love. Gang, gang, gang.